Conversations across time, 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 across time.
The realization of an extreme ideology and a tragic error by the Supreme Court, in my view. The court has done what it has never done before, expressly take away a constitutional right that is so fundamental to so many Americans that had already been recognized.
Complete and utter joy that it was finally overturned, but the determination, a steely determination that the battle is not over.
Abortion bans are illegitimate. Forced motherhood is illegitimate.
You're hearing a lot of passion right there. Let's take a live look outside the Supreme Court in D.C. right now, where a huge crowd has formed, some celebrating the court's monumental decision today, overturning Roe v. Wade. Others pretty furious about it. The justices voted 5-4 in striking down Roe v. Wade, stripping away constitutional protection for abortions that have been in place for nearly 50 years.
Good evening, and welcome to the first in a series of 3 conversations across time that reflects what is going on right now in the country in terms of the rights of women. And so to discuss this matter with you, we have Mr. Irv Madnick, and you all hear me talk about him as defense counsel. But one of the things that happens as an attorney is attorneys like to teach. You teach the jury what you want them to hear. So nevertheless, Irv has agreed to come on board as legal counsel for Conversations Across Time, and he does a fabulous job of teaching the intricacies in layman's language for all to understand about current judicial decisions. So, Irv, welcome, and we have a great panel. I think you're going to enjoy them. Next, our next guest is Justice Blackmun.
Yes. I'm Mark Hoffman. I'm the show historian. I'm portraying Harry Blackmun, Associate Justice to the Supreme Court. I was a staunch Republican. I was appointed to the court in 1970 by Republican President Richard Nixon. I served till 1994. I wrote the majority decision in Roe versus Wade in 1973. 5 Republicans agreed with that decision, and basically, and I'm sure Mr. Madnick will explain both of the decisions shortly, but 5 Republicans agreed with my majority opinion that women have the right to privacy, and they have the right to determine what to do with their own body, including have an abortion up until a certain time.
Justice Scalia.
I am Antonin Scalia. I was a longtime conservative law attorney. I taught at the University of Virginia, and I was a founding member of the Federalist Society. And I was on the United States Court of Appeals before President Ronald Reagan appointed me in 1986 to be an Associate Justice of the United States Supreme Court. I held that position for 30 years until my passing. And for that period, I was the leading intellectual of voicing the conservative wing of the court.
And our next guest, first of all, let me just tell you so you can understand where we're headed with this. The title of this series is No, You Do Not Own My Body. And so our next guest is visiting us from the 18th century. She is, first of all, it was until doing research for this series that I discovered her. And every person that I spoke to was not familiar with this woman. But I actually spoke to two people who had majored in women's studies, and they had never heard of this lady. So Olymphe de Gouges is traveling from the 18th century. She was a French playwright. She wrote many pamphlets, and she was very, very political. And for her forward thinking, and we're going to get into the Declaration of the Rights of Women, which she wrote in 1791. We're going to get into that during this series. But for all of her activity, the decision was made, and I often wonder if this was not a euphemism when they referred to her as an unnatural woman, and she was guillotined. So I introduce you to Madame Olymphe de Gouges. Welcome, Madame Gouges.
It is such an honor. Thank you so much for having me. And it's finally refreshing to have the floor to speak the truth on women's activists and rights. I'm so excited to be here. Thank you for having me.
Well, you couldn't be any more pleased than we are. I'm going to start off with this question. And I really just want you, from your position as 18th century personality, looking at what has happened with women's rights. How do you feel about the direction that this country and maybe the world seems to be headed in terms of the rights of women? I mean, because it's gone full circle since your execution.
Absolutely. So doing the Declaration of the Rights for and of Women was to establish equality across the board, on all playing fields, on all levels, on all outcomes. Coming back in and seeing how everything has gone awry has really disheartened my soul and my spirit. All these new laws, all these new actions, all these political gains, it is so upsetting as a female, as an activist, abolitionist, to hear everything that is going on in the world right now. So many things.
Now, Madame Gouges, and we appreciate your passion. So now we are going to hear from our legal expert. I'd like you to give us a background on the Roe decision and the Dobbs decision. Explain it as only you can.
What I'd like to do is explain the recent abortion decision by the Supreme Court of the United States in the case of Dobbs. Let me explain a little bit of the history. Approximately 50 years ago, the Supreme Court stated that abortion was a right that every woman had. They had the right to get an abortion. This right was based not on a specific instance of, not a specific line of the Constitution, but an implied right in the Constitution that had been decided in a case before the Roe versus Wade case 50 years ago called Griswold. Griswold was a case about contraceptive devices being banned. And what the Supreme Court said in that case is that a state cannot ban contraceptive devices because that was part of the right of privacy of an individual, their health right of privacy, which was implied in a number of amendments to the Constitution, but most specifically in the 14th Due Process Clause addition to the Constitution, the amendment to the Constitution. 50 years after Roe, in the Dobbs case, the Supreme Court, led by a group of right-wing Republican extremists that had been appointed not only during the Trump administration, but previous to that, decided to overturn the Roe decision and state that abortion was not constitutionally granted. Now, they didn't say that abortion was a crime. They didn't say abortion couldn't be had, but they said it was up to the people and not to the courts to decide whether abortion would be a right. That meant that it would go back to the state legislatures or perhaps even the federal government to decide by legislation whether or not abortion would be held in this country as a legal right. The issue is complicated, but I'm trying to keep it as simple as possible. Because they didn't outlaw abortion, it is up to the people. And what that means is, if you are in favor of it, as most people are in this country, then you have a right to change the law. The law in Pennsylvania presently allows for abortion, but the law in half the states in the country abolished the right to abortion and made it a crime. But the federal government can enact legislation to enable abortion. Now, how is this done? Very simply. You've heard me on many, many of these broadcasts say that if you have a problem with the political climate, then you have to get out and vote. And I am doubling down on that now, because that is what it's going to take to change this Dobbs decision in favor of the people who respect the right to get an abortion. Imagine, this was the first time in our history that the Supreme Court has taken a right away from individuals. This is not just a woman's issue. This is an issue for all people, because there are other cases that have been decided on the basis of this right of privacy. Cases like contraceptions, for instance, that I made reference to, and also the right to marry whoever you want to marry. And these cases are now subject to the whim of the presently appointed Supreme Court. So you have to get out and vote, and not just in presidential elections. Midterm elections are coming up and you have to vote here. And not just your vote, but you must have friends that you know are like-minded and maybe have not voted, who can vote and register to vote. Then you have to take those people and bring them along with you to vote. Everybody has to vote, and that's the way we'll be able to change things for the better in this country. Voting is what it's all about. I hope that explains this for everybody, and the rest of the show, I think, will even explain it further. Thank you very, very much for allowing me to make this presentation.
Since I wrote the decision, one of the things that I think the current court, the conservatives from the Federalist Society, missed, they said they went into their originalist mode and said the Constitution makes no right, it makes no mention, and the founders had no concept of abortion. Therefore, there's no constitutional right to abortion. My decision, as you correctly pointed out, was based on the fact that a woman had a right to privacy. We used the precedent in the Griswold case, and so there is when the 14th Amendment was passed, there is and it says everyone's entitled to a due process of law and equal protection of law. There is privacy in the Constitution. The Fourth Amendment talks about privacy. So there is, even the founding fathers knew about privacy. My decision wasn't that abortion should be legal or illegal. My decision and my majority decision was based on the idea that the 14th Amendment gave the women the right to privacy, and as long as her right to privacy didn't interfere with a fetus or some other constitutional rights that might come into play, she had the right to decide if she wanted an abortion or not. And that's where this court made a mistake, even though they attacked me and like my decision was ill-founded. And I blame the Federalist Society, and we'll let Justice Scalia talk about that and the rot he created. But that is where the problem is right now. And by saying there's no right to privacy, and there's no, the founding fathers knew nothing about privacy, is wrong. The 14th Amendment is full of privacy protections.
I'd like to point out, with all due respect, Justice Blackmun, that there is absolutely no mention at all that of any right to so-called right to an abortion or a specific right to privacy.
What's the
And
Fourth
as
Amendment say?
in the Federalist Society, I myself was active in the Federalist Society from its beginning, and I am one of those originalists you mentioned who don't believe in this nonsense about the Constitution being this living document that changes over time. I'm of the opinion that you might call it a fundamentalist view of the Constitution. The Constitution of the United States should be interpreted as it was written by the authors of the Constitution in the Constitutional Convention of 1787, period. As is, and everything that the Constitution guarantees is enumerated
Excuse me, Justice Scalia. Then how do you justify your ruling in Heller when you expanded the right to own guns and pistols and carry guns when that's not specified in the Constitution? So how do you justify that? You're an originalist when it suits your philosophy, and when you're not, you're an activist.
That's because I've been brought up to believe in the respect for authority, and that traditions must be adhered to.
Wait a minute. I have an issue with that.
Of course you do, Ms. Crawford.
And I can see Madame de Gouges like coming out of her seat. First of all, you have when you say you believe in the rights for authority, are you then to suggest that as a male there is to be authority over the bodies of women?
I'm just saying that there is no right specifically enumerated in the Constitution to an abortion. It was never brought up by the authors of the Constitution. Therefore, it does not exist.
Okay. I'm trying to, there's so many thoughts that are going through my mind, and I'm just wondering then, did the United States government have a right to found the space program? Because certainly when the Constitution was written, people didn't know anything about outer space. The whole notion was people travel outer space. I mean,
the law in the Constitution says nothing about outer space. Therefore, it is not relevant to the space program. Is not relevant to the Constitution. As a matter of fact, as an American, I'm very proud of our space program.
Okay, but when you talk about the rights and authority, are you talking about authority over women's bodies? That's what I'm asking.
I'm talking
I'd like the answer to that too, Scalia.
Our tradition, and I'm not going to be judged by some streetwalker. Madame de Gouges, I must point out that just one of the manifesto was
Are you a woman, Scalia? Have you birthed a child before? Do you know what it's like to carry one?
That's not relevant to the law,
It is relevant because if for some reason, as a feminist, as one of free will and free spirit, if we should choose, due to circumstances out of our control, that we see fit, that we should not be carrying a child, we should have the free will choice to choose the abortion.
It's not my fault you make a bad decision. You're just, Madame de Gouges, you just have to live with your bad decision.
What's the bad decision? What's the bad decision?
You had sex without any protection, therefore.
What if it was against my free will?
You had to at some point.
Justice Scalia, what would you think about Griswold? Would you have overturned Griswold?
Of course I would.
No, you wouldn't have. And therefore, what you just said to the madam is totally hypocritical, because you said, well, it's not my fault if you got pregnant. Well, if you think that birth control is also can be outlawed, then what are you saying? You're talking out of both sides of your mouth.
Consistent. I just believe certain traditional values, and
So in other words, the court doesn't have to be
I'm going-
consistent. You
I
can
am
change
trying
your
to-
decisions on a whim.
enforce them in the courts.
Your beliefs are accepted in the courts. Is that what you said?
Look, I have been, excuse me, but I've been brought up in a certain tradition. Excuse me, I've been brought up born in the 30s. I grew up in the 50s and 60s, and I saw the total damn near collapse of our society, what with the stomping around and marching of this or that so-called minority group trying to get some special privileges for themselves.
Wait a minute. Stomping around
period,
and
Scalia.
marching. What are you talking about?
The so-called civil rights marches and
that's what I wanted you to be clear
young
about.
Men.
I think you got hit with a burning bra, Scalia. I think somebody hit you with a burning bra and affected your logic.
Shit. I don't care what you think. I don't care what anyone you think. I stand
know
on
you don't.
principle. You wouldn't know. You lives don't know. I mean, you lives. You're just on the other hand, this. On the other hand, that. No. We are conservatives. We stand on what we believe, and we make damn sure you know it.
Very much reminiscent of the way an autocrat speaks.
Hey, I believe in protecting executive privileges, such as what President Nixon tried to, and President Ford tried to enforce in the freedom of information, and also trying to limit the excesses of the Freedom of Information Act.
So, do you have a right to privacy, Justice Scalia? You have a right to be secure in your own home. Is your home your castle? Do you, as a man, have that right?
I have a right to protect my property.
I didn't ask you that. I asked you, do you have a right to privacy in your bedroom, in your home, as a man?
I did answer your question.
Well, you didn't answer it. I'm asking you, as a man, do you have a right to privacy? A man's home is his castle. You believe in that? Absolutely, right?
Of course. That's my property.
Why do women not have the same right?
Because it's not in the Constitution.
Okay, well, it's not in the Constitution that you can masturbate. Therefore, I say you can't.
You live just sick.
There you go. That's birth control.
You lives are so damn sick.
Justice Scalia, would you speak up? We can't hear you.
You heard me. You heard me, Counselor.
Okay, so listen.
You don't want to answer the question because you do not want women. You grew up as a strict Roman Catholic. You were schooled that way. You're a male chauvinist, and you do not want women to have the same right that you have. And that's basically what you're saying.
Look, I was brought up in the traditional Catholicism before that crap known as Vatican II. And when I was above the dirt, I drove for miles to find a church that did the traditional Latin Mass. The church of the pre-Vatican II church was a rock that stood for something, and none of this both sides of the arguments crap. It stood for something. Adhere to it.
So you would want the madam to be barefoot, pregnant, and stay in her kitchen.
Hey, that's what turns her on.
Okay, that's all we had to hear.
You heard me, madame.
How dare you? What
I
an
do a
insult.
lot of things. On the Supreme Court, I was one of those who decided how the law should be interpreted and what the law is.
But
just as part of my work in the Federalist Society, of which I am proud to have taken part, it was a breeding ground of good, fine conservative attorneys and justices, and the administrations of Reagan and the two Bushes and Trump tapped into us, and we had our people in positions in the federal judiciary, district courts and circuit courts and the Supreme Court. and for the next few decades, we will decide what your rights are. Live with it, madame.
Not if I have anything to do about it.
Yeah, try it.
Oh, I will.
Justice Scalia,
What can you do, madame? In 1792, the revolutionaries guillotined you. I mean, you were too radical even for them.
But okay, so now we understand that you have issues when women exert any power.
And all those so-called minority groups. I'm sick of them.
And have any thoughts of their own. But I'd like to ask you this.
Ask me.
And that is, when you say that you are raised as Roman Catholic in the Catholic tradition, and therefore you know what is right, it sounds almost as if you feel that that view of religion is the only one that should exist in this country under what you've just said. If you can interpret laws for the whole country, a country that's diverse as the United States, with all different races and ethnicities and religious practices and houses of worship. I mean, if you are able to, and those people who don't exercise any religious preference, who are practicing atheists, if you are saying that you, because of the way that you were raised in the Catholic Church, you have the right to impose those beliefs that you learned through church doctrine on the rest of us, it would seem to me that flies in the face of belief in the First Amendment of the Constitution.
You may interpret it as that, counselor. However, I just been brought up with these traditional values, and I was one of those who just got so sick of the upheavals of the 60s and at the start of the 70s. We just had to keep that all under control.
So Justice Scalia, going back to your originalism, then you would have been appalled by the Sons of Liberty. You would have been appalled by Sam Adams. You would have been appalled by Patrick Henry, because they were the same kind of revolutionaries you're talking about in the 60s and 70s, the women's right to march. So you would have been appalled by the founding fathers, and yet you talk about being an originalist. How does that square?
Well, of course, your knowledge of legal history, Justice Blackmun, must show you that a ruling group, a dominant social, economic, political group, will twist the law around for its own benefit. Let's take the case of Plessy versus Ferguson.
Yeah, right.
Yeah,
you would have ruled that separate but equal's okay because the founders said slavery was okay, right? That's what you're saying.
Yeah, that is correct.
Yeah, well, that just shows you where your head is when there's nothing else to be said.
There's all that is important for it. It's all about, Justice Blackmun, is all about a dominant group wanting to maintain their dominance. That's the way it's been. That's the way it's always going to be.
So the Boston Tea Party would have appalled you.
Of course. So, well, I mean,
okay. That's all. Look, thank you for your originalism.
Listen, it has nothing to do with the founding of the country and the founding and the Constitution. May I point out that the men of the Continental Congress were good, respectable men of education, men of standing in their communities, and of course, men of wealth.
They revolted against England, sir. Your originalism is being frayed.
It seems to be a matter of convenience. It seems to be a matter of convenience.
Conversations across time, 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 conversations